सो हमने कॉन्स्टिट्यूशनल लॉ केसेस के पार्ट 1 में 50 केसेस को कवर कर लिया था. अब हम कंटिन्यू करेंगे अपने रिमेनिंग केसेस, दैट इज़ क्वेश्चन केस नंबर 51 से. तो अगर आपने प्रीवियस वीडियो को नहीं देखा है तो आप चैनल पे प्लेलिस्ट में चेकआउट करके भी उसे देख सकते हैं एंड देन फर्दर आप कंटिन्यू कर सकते हैं यहाँ से. सो 51st क्वेश्चन है, केस है, दैट इज़ एसोसिएशन फॉर डेमोक्रेटिक रिफॉर्म्स वर्सेस यूनियन ऑफ इंडिया. ये 2002 का केस है. इन दिस केस द ऑनरेबल सुप्रीम कोर्ट हैज़ mandated the disclosure of information relating to criminal procedure, criminal antecedents, educational qualification and person assets of the candidate contesting election. नेक्स्ट केस है 52nd, लोक प्रहरी वर्सेस यूनियन ऑफ इंडिया. ये 2018 का केस है. इन दिस केस द ऑनरेबल कोर्ट हैज़ डायरेक्टेड टू सेंटर टू अमेंड द रूल्स एज वेल एज द डिस्क्लोजर form filed by the candidates along with their nomination papers to include the sources of their income and those of their spouses and dependents and disclosure of government contracts where candidates or their associates have direct or indirect interest. Next 53rd case है Lily Thomas versus Union of India. This case was decided in 2013 and in this case the Honorable Supreme Court held that Section 8 Clause 4 of the Representation of People Act 1951 was prospectively, that is from the date of the decision, struck down as unconstitutional, being beyond the legislative competence of the Parliament, and also held Section 8 Clause 4 provided that if a MP or a MLA has been convicted of a criminal offence, such MP or MLA can continue to remain and discharge his or her duties as a member of the House if within 3 months of the conviction he or she has filed an appeal or revision against such conviction. This protection is no more available to MP and MLAs and thus on the conviction they lose their seat. Next case है 54th, अभिराम सिंह versus CD कोमचन. ये 2017 का केस है. In this case the court was held that Section 123 Clause 3 of the Act prohibits any candidate, his agent or any person contested by such candidate or his agent from soliciting votes or discouraging voters against voting for a rival candidates on ground of religion, race, caste, community or language by declaring such conduct as a corrupt practice. The court has read this provision to disallow any reference to the religion, race, caste, community or language of the candidates or of his rivals or of the voters to secure votes or prejudice the electoral against a rival in an election. Next case है 55th, Ashwini Kumar Upadhyay versus Union of India. This case was decided in 2018 and in this case the court has held that MPs or MLAs cannot be barred from practicing in courts. Legislator cannot be styled or characterized as full-time salaried employees for there is no relationship of employer and employee. Next case है Public Interest Foundation versus Union of India. ये 2018 का केस है. In this case the court has held politicians cannot be barred from contesting election on framing of charges. Next case is Salla Mudgal versus Union of India. This case was decided in 1995 and this case is relating to the Uniform Civil Code. In this case, the Honorable Court has emphasized on the need for a Uniform Civil Code, which is enshrined in Article 44 of the Constitution. Next case है Indra Keshav Singh 1965. This case is relating to the parliamentary privileges. In this case, the court held that it could not be disputed that in the matter of privileges, the House was the sole and exclusive judge provided such privilege could be found in Article 194 Clause 3. And the court also observed that such privileges were necessarily subject to Article 21 and 22 of the Constitution. Next case है PV Narasimha Rao versus State. ये 1998 में डिसाइड हुआ था and in this case the court has held that those who took bribe but did not vote will be liable for prosecution under the Prevention of Corruption Act. They were not protected or entitled to the community under Article 105 clause 2 of the constitution, whereas those who are voted will protected even though they had taken bribes. Next case है Swapnil Tripathi versus Supreme Court of India. This case was decided in 2018, and in this case the court held that Supreme Court allowed live streaming of court proceedings. Next है Shreya Singhal versus Union of India 2015. In this case the Honorable Supreme Court has struck down Section 66A of the Information Technology Act 2000 relating to restrictions on online speech on grounds of violation of freedom of speech and expression guaranteed under Article 19(1)(a) of the Constitution. Next case है Joseph Shine versus Union of India. This case is of 2018, and in this case the Honorable Supreme Court has held that Section 497, which deals with adultery of the Indian Penal Code, is codified rule of patriarchy. The bench held that Section 198 Clause 2 of CRPC, which gives the husband the exclusive right to prosecute his wife's lover, manifestly arbitrary. Next case है Justice K.S. Puttaswamy retired versus Union of India 2018. ठीक है, ये दो केसेस थे K.S. Puttaswamy में. एक केस था जो आधार से रिलेटेड था और दूसरा था राइट टू प्रिवेसी से. तो ये जो 2018 वाला केस है ये डील कर रहा है आधार से. In this case, the court upheld Aadhaar as a reasonable restriction on individuals' privacy. Upholding the passage of Aadhaar Act as a money bill, the majority opinion upheld that pan-Aadhaar linkage but declared linking Aadhaar with bank accounts and mobile SIM cards unconstitutional. The card was not necessary for children aged between 6 to 14 under the Sarv Shiksha Abhiyan, as the right to education was fundamental right. Court held that Section 57 of the Aadhaar Act was struck down as it was used by the government to compel private companies to demand Aadhaar verification for services. Next case है हमारा Indian Young Lawyers Association versus State of Kerala. This case was of 2018. In this case, the court has held that exclusion of women from the temple of Lord Ayappa was a discriminatory practice which violates the freedom of religion of women devotees. Devotees of Lord Ayappa do not constitute a separate religious denomination, and the prohibition on women is not essential part of Hindu religion. Also, exclusion based on the notion of impurity, menstruation is a form of untouchability. Next case है हमारा Navtej Singh Johar versus Union of India. This is one of the most important case which is asked in almost every examination. So in this case, the Honorable Court has held that Section 377 IPC is irrational, indefensible and arbitrary. The sexual orientation of each individual in the society must be protected on an even platform. For the right to privacy and protection of sexual orientation lies at the core of the fundamental rights guaranteed by Article 14, 15 and 21 of the Constitution. Respect for individuals' choice is very essence of the liberty under law. Section 377 IPC assumes the characteristics of unreasonableness, for it becomes a weapon in the hands of the majority to seclude, exploit and harass the LGBT community. Next case है Olga Tellis versus Bombay Municipal Corporation 1985. In this case, right to livelihood is a facet of Article 21 of the Constitution was held. Next case है John Balloton versus Union of India 1997. In this case, the court declared Section 118 of the Indian Succession Act unconstitutional as violating of Article 14 of the Constitution. It restricted the right of a Christian having a nephew or niece or any other relative as regard his power to bequeath his property for religious or charitable purposes. Next case है DC Wadhwa versus State of Bihar. This case was decided in 1987. In this case, the court held that the power to make an ordinance is to meet an extraordinary situation, and it should not be made to meet political ends of an individual. Repromulgation from time to time is a subversion of the democratic process and a fraud on the Constitution. If ordinance making was made a usual practice, creating an ordinance raj, the courts could strike down pre-promulgated ordinances. Next case है Krishna Kumar Singh versus State of Bihar, 2017. In this case, the court held that requirement of placing the ordinance before the legislature is mandatory. Repromulgation of ordinances is a fraud on the constitution and a subversion of democratic legislative processes. The court also held that satisfaction of the president under Article 123 and of the governor under Article 213 while issuing ordinance is not immune from judicial review. Next case है A.K. Roy versus Union of India 1982. In this case held that President's ordinance making power is not beyond the scope of judicial review. However, the need to exercise judicial review over the President's decision arise only when there is a substantial ground to challenge the decision and not at every casual and passing challenge. Next case है ADM Jabalpur versus Shivkant Shukla 1976. In this case, the court has issues. There was an issue before the court that whether an order issued by the president under Article 359 Clause 1 of the Constitution suspends the right of every person to move any court for the enforcement of the right to personal liberty under Article 21 upon being detained under a law providing for. The court answered in the affirmative, overruled in K. Puttaswamy versus Union of India. Next case है BP Singhal versus Union of India. This case was decided in 2010 and the court has held that the president in effect of the central government has the power to remove a governor at any time without giving him or her any reason and without granting an opportunity to be heard. However, this power cannot be exercised in an arbitrary, capricious and unreasonable manner. The power of removing governors should only be exercised in rare and exceptional circumstances for valid and compelling reasons. The mere reason that the governor is at variance with the politics and ideologies of the central government or that the central government has lost confidence in him or her is not sufficient to remove a governor. Thus, the change in central government cannot be ground for removal of governors and to appoint more favorable person this post. A decision to remove a governor can be challenged in a court of law. Next case है Society for Unaided Private School of Rajasthan versus Union of India. ये 2012 का केस है and in this case the court has held that every citizen has a right to establish and administer school under Article 19(1)(g) so long as the activity remains charitable. Article 29 Clause 1 of the Constitution protects the right of minority to conserve their conserve their language, script or culture, and Article 30 Clause 1 protects their right to establish and administer schools of their choice. Imposing a quota on such schools would result in changing their character and would therefore violate these minority rights. Therefore, the Right to Education Act shall not apply to unaided minority school. Regarding government-aided minority school, Article 29 Clause 2 of the Constitution protects every citizen's right of admission into a state-aided school. Accordingly, the Right to Education Act shall apply to aided minority school. Next case है Pramati Educational and Cultural Trust versus Union of India 2014. In this case held that Society for Unaided Private Schools of Rajasthan versus Union of India and others insofar as it holds that the 2009 Act is applicable to aided minority schools is overruled. The Constitution 93rd Amendment Act 2005 inserting Clause 5 of Article 15 of the Constitution and Constitution 86th Amendment Act 2002 inserting Article 21A of the Constitution do not alter the basic structure or framework of the Constitution and are constitutionally valid. Right to Education Act is not ultra vires Article 19(1)(g) of the Constitution. Next case है SR Bombay versus Union of India 1994. This case is related to emergency provision, that is President rule. In this case, the Supreme Court laid down certain guidelines as to prevent the misuse of Article 356 of the Constitution. Based on the report of the Sarkaria Commission on Center-State Relationship 1988, the Supreme Court also enlisted the situation where the exercise of powers under Article 356 could be proper or improper. also held that secularism is one of the basic feature of the constitution. Secularism is positive concept of equal treatment of all religion. तो इसी केस से आपको 3 क्वेश्चन के आंसर मिल जाते हैं. पहला है कि जो सरकारिया कमीशन था वो किससे रिलेटेड था, तो वो सेंटर स्टेट रिलेशन से रिलेटेड था. और एसआर बोमई वर्सेस यूनियन ऑफ इंडिया, ये आर्टिकल 356 दैट इज प्रेसिडेंट रूट से रिलेटेड तो था ही. इसी के साथ साथ ये जो सेक्युलरिज्म जो है वो कॉन्स्टिट्यूशन का एक बेसिक फीचर है. ये भी स्टेटमेंट दे दिया जाता है और पूछा जाता है कि कौन से केस में ये हेल्ड किया गया था. तो यहाँ से भी आपका एक क्वेश्चन बन सकता है. हमारा नेक्स्ट केस है Ismail Faruqi versus Union of India 1995. In this case, the court has held that the power of acquisition is sovereign or prerogative power of the state to acquire property. Such power exists independent of Article 300A of the Constitution or earlier Article 31 of the Constitution, which may merely indicate the limitations on the power of acquisition by the state. Such acquisition per se does not violate Article 25 and 26 of the Constitution. What is protected under Article 25 and 26 is a religious practice which forms an essential and integral part of the religion. Next case है SP Mittal versus Union of India 1983. In this case, the court has held that the words religious denomination in Article 26 of the Constitution must take their color from the word religion, and if this be so, the expression religious denomination must also satisfy 3 conditions. First is it must be a collection of individuals who has a system of beliefs or doctrine which they regard as conducive to their spiritual well-being, that is a common faith. Second is common organization, and third is designation by distinct name. Next case है the Commissioner Hindu Religious Endowment Madras versus Sri Lakshminder तीर्था स्वामियार ऑफ श्री शिरूर मुट 1954 का केस है. इन दिस केस द कोर्ट लेड डाउन द एसेंशियल प्रैक्टिस टेस्ट. इट ऑब्जर्व दैट what constitute an essential part of the religion will be ascertained with the reference to the tenets and doctrine of all of that religion itself. Next, Selvi versus State of Karnataka 2010. ये केस हमारा एविडेंस एक्ट और जो इन प्रेजेंट PSA है उससे रिलेटेड भी है. इन दिस केस द कोर्ट हैज़ डिक्लेयर्ड दैट 3 prominent police interrogation technique, narco analysis, the lie detection test and the brain mapping violated an accused rights against self-incrimination under Article 20 clause through 3 and her right to life and personal liberty under Article 21 of the Constitution. Next case है MC Mehta versus Union of India. This case is of 1986. In this case, the court has laid down the concept of public liability and absolute liability principle. Next case है Rural Litigation and Entitlement Kendra Dehradun versus State of Uttar Pradesh 1987. In this case, the court laid down the concept of sustainable development. Next case है Indian Council for Enviro Legal Action versus Union of India 1999. In this case, the court has laid down poultry pay principle. Next case है Animal Welfare Board of India versus A. Nagaraj 2014. In this case, the court has prohibited Jallikattu and other animal races and fights, held that animal fights incited by humans are illegal, even those carried out under the guise of traditions and culture. Next है Subhas Kumar versus State of Bihar 1991. In this case, the court has held that right to life includes right of enjoyment of pollution-free water and air for full enjoyment of life. Next case है DK Varsu versus State of West Bengal 1997. This case is also related with the CRPC and BNSS. In this case, the court laid down specific guidelines required to be followed by police while making arrests. Next है Sheela Barsi versus State of Maharashtra 1983. In this case, the court laid down guidelines conferring protection of women prisoners in police lockups. Next is Premchand Garg versus Excise Commissioner UP Allahabad 1963. In this case, the court held that an order which this court can make in order to do complete justice under Article 142 between the parties must not only be consistent with the fundamental rights guaranteed by the Constitution, but it can not even be inconsistent with substantive provisions of the relevant statutory laws. Next case है Union Carbide Corporation versus Union of India. This case was decided in 1991 and the court held that prohibitions or limitations or provisions contained in the ordinary law cannot ipso facto act as prohibitions or limitation on the constitutional powers under Article 142. Next है Supreme Court Bar Association versus Union of India 1998. In this case, the court has observed that powers under Article 142 cannot in any way be controlled by any statutory provisions, but at the same time these powers are not meant to be exercised when their exercise may come directly in conflict with what has been expressly provided for in statutory dealing expressly with the subject. This was said that the said article could not be used to supplant the existing law but only to supplement the law. Next case है Subhas Mahajan versus State of Maharashtra 2018. In this case, the court laid down guidelines to prevent abuse of scheduled caste and scheduled tribes. Prevention of Atrocities Act 1989 held no absolute bar on anticipatory bail. Arrest to be made after a preliminary inquiry. Public servant cannot be arrested without prior sanction. Diluted by amendments made to the Act in 2018. Next case है Government of NCT of Delhi versus Union of India 2018. In this case, the court held that Lieutenant Governor of NCT of Delhi is bound by the aid and advice of the elected Governor of Delhi, except in the matters of land, police and public order. ठीक है? While holding so, the court has observed that in the democracy, real power must vest in the elected representative and Lieutenant Governor cannot interfere in every decision of the Delhi government. The words any matter employed in the proviso to clause 4 of Article 239 AA cannot be inferred to mean every matter. Next case है Maruram versus Union of India 1980. In this case, the court held that the power under Article 72 is to be exercised on the advice of the central government and not by the president on his own, and that the advice of the government binds the head of the republic. Next case है Keher Singh versus Union of India 1989. In this case, the court laid down that the order of the president cannot be subjected to judicial review on its merits except within the strict limitation defined in Maruram. Next case है Epru Sudhakar versus Government of Andhra Pradesh 2006. In this case, the court has held that it is a well settled principle that a limited judicial review of exercise of clemency powers is available to Supreme Court and High Courts. Granting of clemency by the president or governor can be challenged on the following ground. Clemency का मतलब होता है जो मर्सी दी जाती है कैपिटल सेंटेंसेस के केसेस में, उसे हम क्लेमेंसी बोलते हैं. तो ग्राउंड्स क्या क्या है? The order has been passed without application of mind. Order is malified. Order has been passed on extraneous or wholly irrelevant consideration, and relevant material has been kept out of consideration, and order suffers from arbitrariness. Next case है हमारा त्रिवेणी बेन versus State of Gujarat 1989. In this case, the court has held that an undue long delay in execution of the sentence would entitle the convict to approach the Supreme Court under Article 32 or High Court under Article 226 and get his sentence commuted. Next case है Shatrughan Chauhan versus Union of India 2014. In this case, the court has observed that an inordinate and inexplicable delay in execution would preclude carrying out the sentence in cases where the convict in question has committed an offence of terrorism. इस केस में ओवररूल किया गया था देवेंद्र सिंह भुल्लर वर्सेस स्टेट ऑफ एनसीटी ऑफ दिल्ली 2013 के जजमेंट को, which had ruled that a delay in disposing of mercy petition was by itself insufficient ground for commuting the sentence of those convicted to death under anti-terrorism statutes. Next case है Union of India versus Tulsi Ram Patel 1985. In this case, the court held that dismissal, removal or reduction in rank of a person convicted on criminal charges is in public interest and therefore not violative of Article 311 Clause 2 or Article 14 of the Constitution. Next case है पुरुषोत्तम लाल धिंगरा versus Union of India 1957. This case is related to Article 311 and the court held that Article 311 is available only when dismissal, removal, reduction in rank is by way of punishment. So it is difficult to determine as to when an order of termination of service or reduction in rank amounts to punishment. Next case है Union of India versus Balbir Singh 1998. In this case, the Supreme Court held that court can examine the circumstances on which the satisfaction of the president or governor is taken under proviso to Article 311 Clause 2. If the court finds that the circumstances have no bearing whatsoever on the security of state, the court can hold that satisfaction of the president or the governor which is required for passing such an order has been vitiated by wholly extraneous or irrelevant consideration. And the last case is Campaign for Judicial Accountability and Reforms versus Union of India. ये केस 2017 में डिसाइड हुआ था and in this case the court held that Chief Justice is the master of the roster, followed the ratio of State of Rajasthan versus Prakash Chand 1998. So ये थे हमारे 100 क्वेश्चन विच इज़ रिलेटेड टू कॉन्स्टिट्यूशनल लॉ. अदर लॉ से रिलेटेड केसेस को आप स्टडी करने के लिए चैनल को फॉलो करें. तब तक के लिए कीप लर्निंग, कीप शाइनिंग, कीप सपोर्टिंग. थैंक यू. ऑल द बेस्ट.